Hello, my name is Elizabeth Worcester, and I will be going over competency to waive the right to counsel and to represent oneself. Waive the right to counsel. Waiving the right to counsel is not recommended and will probably have a negative effect to achieve a fair trial. And taking away counsel means depriving someone of a legally trained advocate. Ferretta v. California. In this case, in 1975, the Supreme Court held that the Sixth Amendment gives the right to the defendant to represent oneself. Majority Justice Stewart emphasizes that counsel is just an aid and not the main person of interest. Free choices made by the defendant is protected by the Constitution, even if that means a worse punishment for the defendant. Defendant is not incompetent to waive the right to counsel merely because the accused may be unable to understand legal terms and trial duties, and the level of competence required for the decision to waive the right to counsel is higher than to stand trial or plead guilty with the aid of counsel. And unlike Ferretta and Godinez v. Morin, it held that the person who is competent to stand trial is on the same level competent to waive the right to an attorney. So they're at the same level, unlike Ferretta. Trial judge must determine that the decision is also voluntary and knowing, and they must be made aware of the dangers and disadvantages of self-representation so that the record will establish that he knows what they know what they're doing and their choices were made with open eyes. McCassell v. Wiggins and Edwards v. Indiana. In McCassell v. Wiggins, a defendant can continue with no counsel as long as they retain control over the case and the jury understands that they are representing themselves. But standby counsel can provide the defendant with legal advice if needed. In Edwards and Indiana, held that the defendants who are competent to stand trial and represent oneself may be required to accept counsel if they suffer from mental illness, making them incapable to proceed with the trial by themselves. So for my video, this case is about a man named Trevor Summers who was tried for attempted kidnapping and murder of his wife along with child neglect. And in this video particularly, he's about 2 days in his trial and he decides that he wants to defend himself, and this is kind of the exact moment that it happens, and he says that he thinks he's more capable than a lawyer. And I thought this video was interesting because it shows how the judge goes about this when it kind of happens so abruptly, and it shows what the judge that asked Trevor if he's really sure of this decision and what comes with this decision. And I also think it's interesting to read the comments because a lot of them explain like why they think that he decided to defend himself all of a sudden and what his motives were for that. And I thought that was really interesting.
Research related to case.
Evaluations of waiver. Evaluating waiver of counsel and to defend oneself is not really a part of a normal competency evaluation. So when a clinician is evaluating a defendant, they start with a regular competency evaluation, but they also add additional inquiries into whether the defendant is aware of the decision they're going to make and the disadvantages of it. And these inquiries involve assessing the defendant's understanding of legal tasks and duties, such as selection of jury, opening and closing statements, selecting and questioning witnesses, and evidentiary objections. And just like under Edwards, it's a further degree of competency must be looked at in order for an individual to be able to represent themselves in their trial in court. So continue on with evaluations of waiver. Another one important part of the clinician's job when looking at representing oneself is what is the reason behind it and what was the decision making process for this. So clinicians in particular should be alert to the attitudes about the legal process, and that some of those attitudes could be products of a mental disorder, which make them not competent to be able to waive the right to a lawyer. So these could include defeatist attitudes, like they won't help me because I'm guilty, paranoid ideation that like something like all lawyers are against me, um, clearly fantastic objectives like the victim that I killed is not dead, or some sort of irrational beliefs like belief in the supernatural and paranormal, and that those things affect the court and the trial itself. If a defendant wants to defend themselves due to them believing that their lawyer is incapable of fulfilling their duties, or because they think they can do a better job, just like the video I showed in the Trevor Summers case, they are not declared incompetent. Also, clinicians should assess cognitive functions as well, like concentration, reasoning, and communication capacities. Conclusion: courts really have not identified a uniform definition of what constitutes someone competent to waive the right to counsel and to represent oneself. And you can see that in the many cases that I went over. There was a lot of different of how the standards are, and how in Ferretta, um, waiving the right to counsel is higher than being at trial and saying that they're guilty. And in Morin, they are set at the same standards. So you can really see that there is a difference in courts of what they believe should be the standard. And just because of this, clinicians must go through many different inquiries beyond a normal evaluation. And like said before, they have to look at the reason why they made this, and if they understand the disadvantages of this, and also the capability to take on full trial duties and to really work with things that they probably never done before, their mental state in general, and just an overall cognitive evaluation to understand what is happening and why they did it. So for my discussion question, I put, what competency do you think is the most important when evaluating an individual who wants to represent oneself, and why? And I picked this question because due to the fact that there is no uniform standard, I would like to see what other people think the standard should be. And out of all the things that have been over in other cases, what you think the most important is, and to come up with some sort of cohesive, uniform standard for someone to have the right to represent themselves, and what clinicians need to do in order to figure out if they are competent enough. And these are my works cited. Thank you.